Friday. Thank you for joining me. You read the title. This is about DT. You know, I don't say his whole entire name over here. So let me go ahead and get the housekeeping out of the way. Like this video, drop your comments, share this video, and become a subscriber. It does not cost anything. And if you don't know how to subscribe, as you're watching the video, the bottom right corner, you'll see where it's red and it says subscribe. Hit that link and it will take you to subscribing. So let's go ahead and talk about that good old Copyright Act of 1976. This is for fair use. Today, this is about news reporting, teaching, and sometimes, I'm going to throw in there all that good jazz. So, anywho, without further ado, let's go ahead and get into it. Okay, I would like to send a shout out to CNN. Shout out to CNN. And here we go.
In New York, we want to go right now to some pre-recorded audio that is being fed in of the sentencing hearing. You're going to hear from Donald Trump and Judge Juan Merchan. Let's go to that audio now.
Shout out to CNN once again. Shout out to CNN once again.
You're listening to the sound of silence, ladies and gentlemen. The audio is going to get started in just a moment here. We were just hearing from the feed coming out of New York that this was about to get going. Ellie Honig is with me right now. I just want to bring in Ellie. And Ellie, if I cut you off because we're going into the audio, please forgive me. But what we're going to be listening to is basically what just took place, what about 20 or 30 minutes ago when we were playing the highlights of this on the air. We were reading the highlights of what was taking place on the air. We're now going to hear what actually took place.
Right. This was a sentencing of Donald Trump over Zoom. We are hearing some of the sounds of it come through. We'll stop when the real part starts.
Yeah.
But the way this sentencing works is really, aside from the fact that it's the president-elect sitting in the defense chair, it seems like it was a fairly straightforward sentencing. The prosecutor speaks first, then the defense lawyer, then the defendant, Donald Trump, and we know he did address the court in pretty heated fashion. And then ultimately Judge Merchan finishes. It took 35 minutes, which is pretty average for a sentencing. So if you take away the fact that this is the guy who's been elected president, pretty routine sentencing.
Yeah, and it sounds like from what we were hearing just before we came back from the commercial break, you're going to hear about 5, 6, 7 minutes of Donald Trump, 5, 6, 7 minutes of Judge Merchan. It sounds as though at a couple of points, Trump got a little heated in some of his remarks. He obviously still objects to what's taking place today. He is now officially a convicted felon. But it sounds as though Judge Merchan sort of kept his cool and laid out some of his decision-making, the mindset behind some of the decision-making that went into today.
Yeah, the big point that Judge Merchan seems to have stressed is I'm giving you this sentence of unconditional discharge, of no prison or probation or fines, because of your status as the president-elect. I hear some of this coming through now.
Yeah.
I guess we'll yield. Well,
Donald Trump, you're before the court for sentence following the conviction by trial
let's go to the audio now.
34
Let's
counts
listen to
of
this.
falsifying business records in the first degree. Before being sentenced, the court will allow you, your attorney, and the assistant district attorney an opportunity to address the court with any matters relevant to sentencing. For the people.
Thank you. But where's the preferred place for you to stand?
Wherever you feel comfortable.
The defendant in this case, as you know, stands convicted of 34 counts of falsifying business records in the first degree, all Class E felonies. Each carries a range of authorized sentencing options for as much as 1 1/3 to 4 years in state prison to a variety of non-incarceratory sentences. In this court's January 3rd decision on the defendant's Clayton motion, Your Honor indicated an inclination to impose an unconditional discharge. Under all the circumstances of this case, its unique posture and the defendant's status as president-elect, the people recommend a sentence of an unconditional discharge. In finding the defendant guilty in this case, the jury necessarily found unanimously that the defendant falsified 34 separate entries in his business records with the intent to defraud, which included an intent to commit or conceal a conspiracy to promote his own election by unlawful means. Having presided over the trial, Your Honor is very familiar with the conduct, its seriousness, and the overwhelming evidence to support the jury's verdict. I'm certainly not going to rehash that now. In last week's decision on January 3rd, this court referred to the gravamen of the defendant's conduct, his criminal conduct in this case, as constituting, quote, premeditated and continuous deception. The verdict was delivered by a jury that was carefully chosen using an extensive questionnaire based on suggestions from both parties and after thorough questioning of the prospective jurors by both sides. The verdict in this case was unanimous and decisive, and it must be respected. As this court has observed, quote, the sanctity of a jury verdict and the deference that must be accorded to it is a bedrock principle in our nation's jurisprudence. The defendant's conduct before, during, and after this trial also merits consideration. Instead of preserving, protecting, and defending our constitutionally established system of criminal justice, the defendant, the once and future President of the United States, has engaged in a coordinated.
Sorry about that, guys.
Far from expressing any kind of remorse for his criminal conduct, the defendant has purposefully bred disdain for our judicial institutions and the rule of law. And he's done this to serve his own ends and to encourage others to reject the jury verdict that he finds so distasteful. He has characterized these proceedings as corrupt, rigged, a witch hunt, or a sham too many times to tabulate. The defendant's rhetoric has only ratcheted up since this court's rulings on his motions to dismiss. He has been unrelenting in his unsubstantiated attacks upon this court and its family, individual prosecutors and their families, the witnesses, the grand jury, the trial jury, and the justice system as a whole. The defendant has not only been held in contempt by other jurists in other matters, but this court alone found the defendant in contempt for 10 distinct violations of the order restricting extrajudicial speech. In his legal filings, the defendant has used dangerous rhetoric in leveling accusations of intentionally unlawful and unconstitutional conduct on the part of this court and the prosecution. As this court has noted, the defendant's conduct, quote, constitutes a direct attack on the rule of law itself. Moreover, the defendant has publicly threatened to retaliate against the prosecutors who have sought to hold him accountable in this and other matters, and the courts who have endeavored to fairly and faithfully adjudicate these matters. Such threats are designed to have a chilling effect, to intimidate those who have the responsibility to enforce our laws, in the hopes that they will ignore the defendant's transgressions because they fear that he is simply too powerful to be subjected to the same rule of law as the rest of us. In his 2024 end-of-year report, United States Supreme Court Chief Justice Roberts warned of the dangers of such conduct. Quote, public officials too, regrettably, have engaged in recent attempts to intimidate judges. For example, suggesting political bias in the judge's adverse rulings without credible basis for such allegations, end quote. Chief Justice Roberts continued, quote, attempts to intimidate judges for their rulings are inappropriate and should be vigorously opposed. Public officials certainly have a right to criticize the work of the judiciary, but they should be mindful that intemperance in their statements when it comes to judges may prompt dangerous reactions by others. Chief Justice Roberts also spoke of the dangers of disinformation, which are, quote, magnified by social media, which provides a ready.
Sorry about that, guys. It's not on my
false
end.
information. Put simply, this defendant has caused enduring damage to public perception of the criminal justice system and has placed officers of the court in harm's way. In the probation report, which we just received this morning, the author, having interviewed the defendant, noted that the defendant sees himself as above the law and won't accept responsibility for his actions. And that's certainly consistent with everything else that we've seen. Now, in a typical case, both the offense conduct and these other exacerbating factors would impact the appropriate sentence. But in this case, we must be respectful of the office of the presidency and mindful of the fact that the defendant will be inaugurated as president in 10 days. Any undischarged portion of a sentence has the potential to interfere with the defendant's performance of the duties of his office. As a practical matter, the most sensible sentence prior to his inauguration is an unconditional discharge. The court has expressed an inclination to do exactly that because, in the court's words, quote, the most viable solution to ensure finality and allow defendant to pursue his appellate options is to proceed to sentence. As you know, in New York, a conditional discharge is authorized by penal law, quote, if the court, having regard to the nature and circumstances of the offense and to the history, character, and condition of the defendant, is of the opinion that neither the public interest nor the ends of justice would be served.
It's not mine, guys.
Supervision is not appropriate. An unconditional discharge is authorized if a conditional discharge is authorized and, quote, if the court is of the opinion that no proper purpose would be served by imposing any condition upon the defendant's release. Because these crimes are felonies, the court must set forth in the record the reasons for its action. The American public has the right to a presidency unencumbered by pending court proceedings or ongoing sentence-related obligations. But imposing this sentence ensures that finality.
Come on.
Sentencing the defendant permits this court to enter judgment, to cement the defendant's status as a convicted felon while he pursues whatever appeals he intends to pursue. And it gives full effect and respect to the jury's verdict while preserving the defendant's ability to govern. People therefore recommend that this court impose a sentence of an unconditional discharge. Thank you.
Thank you. Counsel.
So pretty much he's above the law.
Thank you, Your Honor. I very much disagree with much of what the government just said about this case, about the legitimacy of what happened in this courtroom during the trial, and about President Trump's conduct fighting this case from before it was indicted to while it was indicted, to the jury's verdict, and even to this day. What the government just said presupposes something that we disagree with very much, which was that this was an appropriate case to be brought. It was not. This case, without a doubt, knowing everything we know about the timing of the investigation, the fact that multiple prosecutors looked at the facts of this case, including prosecutors within the district attorney's office in New York County, and made a decision not to bring charges. As the court knows, shortly after President Trump announced his intention to run for re-election, this case was started for what amounted to a third time, which brings us ultimately to where we are today. A lot of what the government just said presupposes that this case is legally appropriate and that the charges that were brought by the people were consistent with the laws of New York. Again, we very much disagree with that. And as everybody has been noted, because it's true, we certainly intend on appealing that. And it's not, by the way, just counsel and President Trump that feels that way. There's many legal experts that share the same views that I just said, which is that legally this case should not have been brought, both based on the facts that were established at trial and also on the legal basis for which they were brought. But it's also not just the legal experts, not just counsel, and not just President Trump, but the majority of the American people also agree that this case should not have been brought. I mean, the interesting thing about the fact that there was a trial for the first time in our history, a criminal trial during an election season, is that the American voters got a chance to see and decide for themselves whether this is the kind of case that should have been brought. And they decided. And that's why in 10 days, President Trump was going to assume the office of the President of the United States. And certainly we're here for the court to sentence President Trump to an unconditional discharge. And for that, it's a very sad day. It's a sad day for President Trump and his family and friends, but it's also, in counsel's view, a sad day for this country because this was a case, without a doubt, that was brought by a district attorney who promised that he would go after President Trump if elected and felt like he had to go through with that promise. And so that's sad. And I hope, and I know that President Trump shares this view, that this will never happen again in this country. And so we certainly understand where we are today. We very much intend on pursuing an appeal of this verdict and what happened during this investigation. And we certainly believe that the only appropriate sentence, if one's to be imposed at all, which we very much believe it shouldn't be, and that the case should be dismissed, is a sentence of an unconditional discharge. Thank you.
Thank you. Would
Child,
your client like to be heard?
I hope not.
Yes, thank you, Your Honor. This has been a very terrible experience. I think it's been a tremendous setback for New York and the New York court system. This is a case that Alvin Bragg did not want to bring. He thought it was, from what I read and from what I hear, inappropriately handled before he got there. A gentleman from a law firm came in and acted as a district attorney. And that gentleman, from what I heard, was a criminal or almost criminal in what he did. It was very inappropriate. It was somebody involved with my political opponent. Part of the records that we're talking about, they're saying, I just noticed where he said I was falsifying business records. Well, the falsification of business records, as they say, it was calling a legal expense in the books where everybody could see them, a legal expense. In other words, that legal fees or legal expense were put down as legal expense by accountants. They weren't put down by me. They were put down by accountants. I didn't call them construction, concrete work. I didn't call them electrical work. I didn't call them any. They called a legal fee or a legal expense. And for this, I got indicted. It's incredible, actually. Now, if you look, my attorney alluded to it, the top legal scholars and legal pundits in this country, the ones that are quoted all the time on television that are making their views felt and highly respected people,
Goodness.
have said, everyone, virtually everyone that I know of, I haven't seen any to the contrary, not one. And none of these people are not exactly friends of mine, to put it mildly. But they all said this is a case that should have never been brought. It's an injustice of justice. Very respected Jonathan Turley, Andy McCarthy, Judge David Rifkin, a wonderful man who just passed away, by the way, Greg Jarrett, Ellie Honig from CNN, of all places. CNN said,
Guys, that's it. I cannot take any more of his voice. I am so sorry. I cannot do it. I cannot do it. This is the bottom line. The bottom line is that DT, because that's what his name is over here, DT was pretty much let off because he is soon to be sworn in. So my thing, I have two questions. Why rush the sentencing? Why rush it? You could have just waited, because that's what they said they were going to do. They were going to wait till he finishes 4 years and then pursue sentencing charges then. So he pitched a fit about that. My other question is, why not put conditional, why not? Instead of saying unconditional discharge, why say you should have done conditional? He still could have done what he needed to do. The conditions could have easily been, we will pick the matter back up after he's done with the presidency. That could have been the only condition. You didn't have to put other conditions on there. They're making it and want us to eat this crow like, oh, well, he's a convicted felon. So what? He was that when he, won the election. We don't care about that. We wanted to hear some sentencing. That's what I wanted to hear. I wanted to hear some sentencing. I don't want to hear the violin playing of, oh, well, he's the president, he can't do his job. Well, guess what? At the end of the day, this was one of the lesser charges. This wasn't even the meat and potatoes of the charges. And the Joshua Steinglass, who is the prosecutor, stated that there were 34 separate accounts. 34. So for me, all I can say to anyone that's hearing this, go ahead, get yourself prepared for the next 4 years, because this is showing and telling him that he can do whatever he wants to do. That's my opinion. And the other thing is that I don't see why I'm gonna be honest. Don't be surprised when his attorney allegedly say that. Well, I think they're going to file to try to get the felony charges off him. Don't be surprised if that poof, like puff the magic dragon and disappear, because his goal is not to have a stain on his record. That's his goal. But for us as Americans, it's not about just the voting. It's about the fabric of our lives. It's about us holding anyone. No one should be upon reproach unless you're God. It does not matter. That's why there are checks and balances put in place, so the president, no matter who it would be, wouldn't be able to make any decisions without, the House or the Senate or whoever going back and saying, no, you can't do this. It's checks and balances for a reason. Checks and balances. When this country was made, and yes, unfortunately, it was made on the back of our people. It was not made to say, okay, I don't think we ever seen this coming. I don't think, as Americans. Now, the people that are in higher up positions and, back in the dark corners of politics and old money, they've seen it. They know it. Please believe, and this is my opinion, there is nothing going on. Like, if people really wanted DT to be sentenced, he would have been sentenced. He would have been sentenced. And I truly feel he was put in his position for a reason. For a reason. Because we all know that Kamala was over and still is overqualified. If the definition of conditional discharge is, it says, despite the lack of criminal record, a conditional discharge indicates that you were found guilty of a crime and can create a negative impression for a prospective employer, in this case, for us. So it's okay for him to be a convicted felon and be unconditional. You didn't do what you were supposed to do for the American people. Just because people voted for him, that doesn't mean that that speaks for everyone. I'm really like, I'm not even pissed off about it. Um, because at the end of the day, I said to myself that I didn't know which way this judge was going to go, but it was too quick. It was too quick. And now he's going to go for wanting the felony charges or the felonies off his name. And I would not be surprised, allegedly, if it happens. I really would not. Yes, I'm done with it. I got to get on with my day. I can't let this stuff get on my nerves. It's really getting on my last damn nerve. So I couldn't even take his voice anymore. I'm sorry. I know I'm supposed to be above certain things, but guess what? I'm not. Mhm. I am not. Let's see here. It says, let me share the screen with you guys, because I'm just so. I mean, they could have at least did conditional. I mean, really? Okay, let me show you what I'm looking at here. Felonies in elective offices. Do felony need a pardon to run for office? It states here, but even if some states were, the vote is stored automatically, felons still need to get a pardon or expungement to run for office. That's what it's stating. Is DT has been found and charged with, well, not even charged or sentenced with unconditional discharge, meaning he will not have anything that he has to answer for because he is about to be sworn in. And they feel that, they don't want any of his duties to be hindered. How can his duties be hindered if you did conditional and the conditions could have been placed on that he can perform all of his duties, but once he is no longer the president, he will be sentenced. What is so hard about that? Within stating that, I hope everyone have a great Friday. Stay warm. And until next time, and make sure you hit the like button anytime if you're hitting a replay or anything, make sure you hit the like button. And if you're not a subscriber, become a subscriber, because this right here was for the birds. This was a waste of time. I'm sorry. That's how I feel. I'm sticking to it. Until next time, peace and soul. Love you guys.